Hello. Today we're looking at equitable maxims. Equitable maxims are equitable principles which had been formulated by the Court of Chancery in order to guide the judges in whether to apply equity or not. So equitable maxims are catchy phrases which helps a person remember. You may come across some of these maxims in the course of your lectures in other subjects apart from equity and trusts. And the list that I've given you is just a taster. There are other equitable maxims, which again, we will come across more later as well in the course of following lectures in equity and trusts. So let's start with the first maxim. Before we continue, make sure you have the lecture notes in front of you. You can find it on Moodle. It's labeled Equitable Maxims. Right, moving on to the next slide. The first maxim we're looking at is equity acts on the conscience. It just means that equity acts on the conscience of the legal owner, the person who owns the property, to prevent this person from acting in an unfair or unconscionable manner by defeating a common intention. A common intention could have been a promise that was made earlier. An example was given in the case of Browne and Edwards, and the quotation that you can see, it came from this case. So in Grant and Edwards, the claimant here was Miss Grant. She was separated from her husband and she moved in with Mr. Edwards. He bought a house, Mr. Edwards bought a house, and she moved in with him with their 2 children and 2 children from her previous marriage. Okay. The house was bought by Mr. Edwards in joint names between himself and his brother Arthur. His brother Arthur had no interest, no beneficial interest in the house. It was just to facilitate the mortgage, that's it. When she moved in, Mr. Edwards told Miss Grant that the house was for the both of them and their children. And the reason her name wasn't on the deed was that it might prejudice her divorce proceedings. So Mr. Edwards paid the deposit to the house as well as the mortgage installments. But Miss Grant made substantial contributions to the household expenses. The couple later separated and she claimed a beneficial interest in the house. So Mr. Edwards is now saying, but she doesn't own an interest in the house because he paid for both the deposit as well as the mortgage payments. The court disagreed with him and used this maxim, equity acts on a conscience. On whose conscience? On Mr. Edwards' conscience, because of the promise he made to Miss Grant when she moved in that the house was for the both of them, and based on this promise she made substantial contributions to household expenses. We're going to look at this case in more detail under trust of family home later on as well, but for now it's just so that you understand what the maxim equity acts on a conscience means. In this case, it acted on the conscience of the legal owner of the house, Mr. Edwards, to prevent him from denying Miss Grant what he promised her when they moved in. There was a common intention when she moved in the house that it was for the both of them. Right. Next is equity acts in personam. Historically, common law courts judgments were made in rem, R-E-M, meaning against the thing or against the property. The court of equity, however, can act in personam, And what this means literally is against the person. The advantage of this is it allows the court to order an individual to obey their judgments, so long, obviously, as the individual is before the court. And this means that even if the property owned by this individual is not within the jurisdiction, it doesn't matter, because the individual, the person, can be ordered to transfer the property to the rightful owner as the court defines. So equity acts against the person. Equity acts in personam. Next, equitable remedies are discretionary. So this is one of the main principles of equity, that it is discretionary. You have to apply to the court if you want an equitable remedy, but the court doesn't have to say yes to you. It is entirely at the court's discretion whether or not to grant an equitable remedy. As to what remedies are equitable in nature, that's the next lecture. Okay? Right, so it's not granted as of right. The court has full discretion whether or not to grant equitable remedies. The only remedy that is granted as of right if you are in court and you win your case is damages. And that's because damages, as in money, that's a common law remedy. But equitable remedies are discretionary. So using the case of Flight and Bolland as an example, in this case, the claimant was asking for specific performance. Specific performance just means that an order forcing the defendant to perform what was promised in an earlier contract. So in this case, the claimant won the case and was asking for specific performance. However, in this case, the claimant was a minor. Now, at that time, this was Flight and Bolland 1828. At that time, it was 21. Okay. Any minor is a person under the age of 21. So the claimant was a minor. Now, there is a rule, there's a maxim that equitable remedies cannot be granted against a minor. So because equitable remedies cannot be granted against a minor, the doctrine of mutuality means that equitable remedies cannot also be granted in favor of a minor. That was what was decided anyway by the court in Flight and Bolland. But as we'll see later, when we look at equitable remedies, at the lecture on equitable remedies, the court has relaxed their attitude in this area. Next, maxim, delay defeats equity. This is based on the doctrine of laches. So Laches. It just means that if a person knows that they have grounds to sue and they don't take advantage of it immediately, they wait too long. And by the time they do take the case to court, if the court feels that they've waited so long that it becomes unreasonable, inequitable to give them an equitable remedy, they will say delay defeats equity. Now, this does not mean that they're not entitled to a remedy. I mean, so long as they're within the limitation. The Limitation Act 1980 provides a list of how long you have to take action for all types of injuries. Okay, but so long as they're within the Limitation Act and they sue and they win, they can still be granted damages, as I've said before, because damages is as of right. It is a common law remedy. But it's when they're asking for an additional equitable remedy, that's when the court will say, hold on, it's been too long, no longer equitable to grant you this remedy, so we're just going to give you damages. So delay defeats equity. Next, he who comes to equity must come with clean hands. And he who seeks equity must do equity. They mean more or less the same thing. I mean, the former, he who seeks equity must do equity, is more to do with the claimant who is seeking the equitable remedy must first have done what is right and fair by the defendant. And the latter, he who comes to equity must come with clean hands, means if you're seeking an equitable remedy from the court, you must have clean hands, you must have a clear conscience as regards your past actions. So let's look at a couple of cases, and you should find these cases in your notes. The first one, he who seeks equity must do equity. We can use the case of Chappell against Times newspaper as an illustration. There was an injunction which was sought by the claimant to restrain the defendant. The defendant was an employer, a newspaper company, employer, from terminating the claimant's contract of employment. So the claimant, an employee of this newspaper, was seeking an injunction to stop his employer from terminating his contract of employment. But the court refused to grant the injunction because they felt that, the claimant wasn't acting equitably, because the claimant, being a member of the union, refused to refrain from strike action. So he who seeks equity must do equity. The next one, he who comes to equity must come with clean hands. That means if you are seeking an equitable remedy, you must ensure that you haven't done anything in the past, which would mean that you haven't come to court with clean hands. So, the case of Overton and Bannister, this case was based on the defense of breach of trusts, which relies on the beneficiary's consent. I realize we haven't done trust yet, and I realize that you may not understand some of the terminology that I'm using, but it's something that will come to you once we start with trust and so on. So I'm going to try and simplify it as much as possible now. So in this case, a beneficiary to a trust, someone who was entitled to a benefit under a trust, was a minor. Now, this person lied about his age to persuade the trustees to pay over trust money to him. Once the trustees had done that, once they paid over trust money to him, they are in effect in breach of trust because they have paid someone they weren't entitled to pay. He was still a minor at the time. So the trustees are now being sued for breach of trusts by the other beneficiaries as well as by this one who lied. Okay, so the minor beneficiary, the one who fraudulently misrepresented his age, is now saying, well, the trustees cannot rely on this defense because when you're being sued for breach of trust, you as a trustee, you can raise defenses. One of the defenses you can raise is that you did what you did, i.e. you breached the trust, but you had the consent of the beneficiary in doing so. And if you're able to prove that, then the court will excuse you from breach and you won't be found liable. In this case, the minor says, but they can't rely on this defense because I was the one giving them the consent, and I was still a minor when I gave this consent. Therefore, my consent was of no use. The court said in this case the minor cannot claim this. Okay, so he wasn't permitted to deny that his consent was ineffective due to his age. There are lots of other instances of he who comes to equity must come with clean hands. Another one, not using a case here because I'm aware that Overton and Bannister may be a bit too overcomplicated considering you're just now starting on trust. Another one would be something that you will come across in land law, and that is the landlord and tenant situation. So let's say, so between a landlord and a tenant, the landlord may have promised to do certain things to do with the lease, the tenants will promise to do certain things. So let's say in this particular example, the landlord promises to make sure that the premises are in good repairs. Yeah, that he'll keep the premises in good repairs, especially the roof and the surrounding structure. And the tenant's promise or covenant would be to pay rent. Okay, so tenant, let's say, is in arrears, hasn't paid rent for the past 2 months, and there's a hole in the roof and it needs to be repaired. There's rainwater coming in, let's say, every time it rains. So the tenant is now going to court because the landlord's refusing to repair, and the tenant is asking the court for an equitable remedy. And what would the equitable remedy be? It would be specific performance, which is, as I say, an order for the defendant to do what was promised. So an order for the landlord to do what was promised, which was to repair, to keep the premises in good repair. Now the court would probably refuse to grant the tenant the order of specific performance, forcing the landlord to repair, because the tenant did not come to equity with clean hands. Why not? Because the tenant himself, the person who's applying for specific performance, this equitable remedy, hadn't paid rent in the past 2 months. So the court may very well say, if you want us to grant you specific performance against the landlord, you must first make sure you're up to date with your rent money. Okay, so he who comes to equity must come with clean hands. Right, the next one, equity does not suffer a wrong to be without a remedy. This is the foundation of equity, basically, developed due to the defects in the common law. Every single case that we've looked at so far, every single example that we've looked at so far is an example of equity not suffering a wrong to be without a remedy. So wherever possible, if there is no relevant or appropriate remedy at common law, equity will try to provide it. Next is equity follows the law, but only insofar as there's no conflict. So if there is no conflict, equity is happy to follow the law. But in the case of a conflict, as you know from the Judicature Acts, equity prevails. Equality is equity is the next maxim. An example of equality is equity that I've given you is equity's preference of the tenancy in common over the joint tenancy. This comes from co-ownership, and it is a topic that you will be covering in land law. To simplify, there are two ways. Let's say you have more than one person owning a piece of land. There are two methods of holding it. Either those two people hold the land as joint tenants, or they hold the land as tenants in common. Now, joint tenancy means that when one person dies, their interest automatically passes to the survivor. So the person who survives, the last survivor, takes everything. But a tenant in a tenancy in common, if they were holding the piece of land as tenants in common, when one person dies, this person's share of the land will pass to their estate, and it will pass to whomever they've left it to in the will. That is obviously the fairer method, which was why equity prefers tenancy in common over the joint tenancy. Hence, equality is equity. Next is equity will not permit or allow a statute to be used as an instrument of fraud. There are many ways to phrase this particular maxim. You might find in certain textbooks that equity will not allow an act of parliament to be used as an instrument of fraud. It all means the same thing. A classic example, an example which I think a lot of students tend to remember even after they've finished the exams on equity in trust, is the case of Bannister and Bannister. In this case, it was an aunt and a nephew. It was an aunt and a nephew. And the aunt here owned 2 cottages. She sold both her cottages to her nephew at below market value, on the oral understanding that she be allowed to live in one of the cottages for the rest of her life. Once the sale had gone through, guess what? The nephew tried to take possession of both cottages, including the one she was occupying. Right. So she's there in court now, and he's saying, I'm entitled to both cottages. She has to leave. I want to kick her out. And she says, but we had an agreement. But the problem with this, with her claim that they had an agreement, is an agreement where the subject matter is land, in order to be valid, must be written. It must comply with legislation. You don't need to know which one it is now, but it must have been written. It must contain their names. It must be signed by both of them. There was no such thing, as we said, because it was an oral agreement. Another thing that she tried to claim was, okay, even if she can't prove that there was a contract, because there was nothing in writing to prove the existence of that contract, she could claim that he's holding the cottage on trust for her for the rest of her life. There is also a problem with this, because there is a piece of legislation which says if you're creating a trust where the subject matter of the trust is land, it is land because it is a cottage, then again it must be evidenced in writing. So, as we said, there was nearly an oral agreement between the two of them. So, based on the strict letter of the law, if it was common law, she would have been entitled to nothing. The nephew would have the right to evict her from the cottage. But using the maxim that equity will not allow a statute or an act of parliament to be used as an instrument of fraud, the court was able to, based on the agreement that they had, clearly she could prove that she sold the cottages to him at an undervalue, and clearly she wouldn't have left herself without any place to live. The court was able to deduce that there was fraud in this case. The nephew was trying to use these various statutory provisions as a means of getting rid of his aunt. They were able to give her the right, to provide her the right to live in the cottage for as long as she wanted to. And the next maxim, equity looks to the substance and intent rather than to the form. Right. What this means is the form here, it's actually a technical term, but the form as in formalities, as in what do the documents that was signed say. Okay. Substance and intent is what led to the signing of these documents, for example. And equity is concerned not so much with what black and white says, but what led to those documents. And again, Bannister and Bannister is a classic example. So looking at Bannister and Bannister, who was the legal owner of the cottages? The nephew. The documentation, the deeds, everything says that the nephew is now the legal owner. And as the legal owner, obviously, the nephew would be entitled to do whatever he wishes, including evicting his aunt from the cottage. But equity isn't concerned with the form or the formalities. They look at the substance and the intent. What was behind it? How did the nephew come to own these two cottages, and why is the aunt now claiming that, she has the right to live in one of them? Well, looking at the substance, the nephew bought both cottages at an undervalue, clear evidence that there was something else behind it, not just a straightforward sale. And what was the intention? The intention was that the aunt gets to live in one of the cottages for the rest of her life. So because of that, using this maxim as well as the one before, the court was able to come to the conclusion that the aunt had the right to stay. The final slide. Equity looks on as done that which ought to be done. A classic example of this, and again, I know I keep saying this, but there is a lot of correlation between equity in trusts and land law. It is something that you will come across in land law. So I prefer to use land law examples so that you're able to, when you're listening to that particular relevant lecture in land law, you think, oh, okay, this was what we did in trusts. Okay, so a contract to perform an act is treated in equity as if the act has been performed. So how does that work? Let's take a contract of sale of land as an example. So the vendor has agreed by contract to sell land to the purchaser, right? So the vendor, V, enters into a contract to sell land to the purchaser. So long as the contract is a binding contract, and a binding contract just means that all the elements of the creation of a contract is present. For those of you who have already done contract law, I'm sure you know it means there was offer, there was acceptance, there was an intention to create legal relations, and consideration, some money had changed hands. So long as all of these elements are there, and also with land contracts, as I said earlier when we were looking at the case of Bannister and Bannister, it must also comply with a piece of legislation. It's Section 2 of the Law of Property Miscellaneous Provisions Act 1989. You don't really need to know the provision at this stage. You will go through Section 2 in a lot of detail in your land law syllabus. But anyway, so long as all of these have been complied with, then there is a binding contract between the vendor and the purchaser for the vendor to sell his house, let's say, to the purchaser. Okay, so at this point, there was merely a contract between the two, between vendor and purchaser. Vendor hasn't actually transferred legal title yet. Okay? Transfer of legal title requires another document, which is not the contract. It is a deed of conveyance, and we'll look at what a deed of conveyance is later. And you will do it as well in land law. Okay, so far there's only a contract between the two. What if one of the parties decide they don't want to go through with the contract? Can the injured party sue for breach of contract? Obviously, yes, they can sue for breach of contract. And there's been a clear breach of contract. So if the vendor decides not to sell, the purchaser can sue, and they will be successful because there's a clear breach of contract. And the purchaser would be entitled to a grant of or an award of damages, because that is a common law remedy. It is granted as of right. Soon as you won your case, you can claim damages. It's as of right. But in this case, the purchaser may want something more than damages. They want the house. They have their heart set on the house. They want to buy the house. So what other remedy would they be asking for? Well, they will need an equitable remedy, and we've mentioned this already, the equitable remedy of specific performance, which is an order for the vendor to do what he promised under the contract, which was to sell the house to the purchaser. So because of this maxim, equity looks on as done that which ought to be done. What ought to be done? Well, it was the promise for the vendor to transfer the house to the purchaser. Equity deems it as being done, which then gives the purchaser the right to apply and be awarded an order of specific performance, which will then force the vendor to do what he promised in the first place. So the right to ask for and be awarded the remedy of specific performance is all down to this maxim that equity treats as done that which ought to be done. Some books will say equity deems as done that which ought to be done.